If you own rental properties in California, you may be sitting on a gold mine, but you're also sitting on a potential lawsuit waiting to happen. Today, I'm going to walk you through the 3 main ways to protect your rental properties from liabilities and help you understand which option makes the most sense for your situation. Hi, I'm Ali Talai, a trust and asset protection attorney and also founder of Talai Law Offices. I recently started making videos on social media with the goal of providing educational content that helps individuals and families make smarter decisions about estate planning, asset protection, and preserving generational wealth. I am passionate about helping clients create estate plans that protects their legacy and not just distributes their assets. Estate planning, in my opinion, is full of legal nuances that can impact both your family and your financial future. And that is why I like to invite you to join my webinar. This webinar is great for someone that is looking to set up their estate planning. The webinar is called Avoiding the 5 Biggest Estate Planning Mistakes. You can register at talailaw.com. That's TALAI law.com under the event page, or you can simply click in the link below in the description. Let me start with a story that might sound familiar. Last year, I had a client who owned 4 rental properties in Orange County. He owned everything under his personal name, and unfortunately one of the tenants ended up filing a lawsuit against them, claiming that the property wasn't maintained properly, and because he owned everything under his personal name, his entire portfolio was at risk. We're talking about his primary residence, we're talking about the other rental properties, his investment accounts, everything was at risk. And the reality of it is that this is not an unusual scenario. In California, rental property owners face unique risks. We have some of the most tenant-friendly laws in the country, and our courts regularly award substantial damages in premise liability cases. California Civil Code Section 1714 establishes property owners have a duty of ordinary care to maintain their properties in a reasonable, safe condition. Great law. That should be there, and the landlord should follow that. However, when something goes wrong, the liability can be devastating, and that's why having proper asset protection planning, having proper insurance in place becomes essential. So with the client that I was just telling you about, proper asset protection planning could have completely changed the outcome of the case. Instead of risking everything, my client could have limited his exposure, worst case scenario, to the equity in the property that the lawsuit was filed against. Let's start with a common structure, that is the limited liability company or the LLC. When you transfer your rental property into an LLC, you're creating a legal barrier between your personal assets and the property. This is often called a liability shield, and under California Corporation Code Section 17703.04, LLC members are generally not personally liable for the debts and obligation of the LLC. Sounds great, right? But here's the reality. The protection isn't bulletproof. In most lawsuits, especially those involving tenant injuries or property conditions, plaintiffs will often sue both the LLC and the owner, arguing that the owner was directly involved in the management of the property. If they can prove personal negligence, like failing to address safety issues or mismanaging the property, you could be personally liable even if the property is inside of an LLC. So if you're hands-on with your rentals, an LLC alone won't fully shield your personal assets. You will need additional asset protection planning. That might mean separating properties into different LLCs, using umbrella insurance, or structuring ownership more strategically. In my opinion, where a lot of landlords get it wrong is that they think LLC protection is automatic. But the reality is that you have to follow basic formalities. You got to make sure you keep business and personal finances completely separate, maintain clear records and contracts, don't sign the LLC's contract under your name only. You got to treat the LLC as a real business, not just the side hustle. If you don't, courts can pierce the corporate veil and hold you personally liable anyways. All right, so let's talk about trust options. Estate planning meets asset protection. Here's what you need to know. Revocable living trusts offer zero asset protection while you're alive. And that's because you retain full control and you can revoke or amend and change anything within the trust, and the law will treat the assets that are held inside of the trust as if you own them. That means if a creditor files a lawsuit against you, they can reach inside the assets in the revocable trust. If your goal is real asset protection, you could set up and look into an irrevocable asset protection trust, specifically something like a domestic asset protection trust. These trusts can offer strong asset protection against future creditors if they are set up correctly and they're set up in advance before there is a lawsuit, before there are any legal issues. The key difference with an irrevocable domestic asset protection trust is that you're placing assets into a trust that limits creditors' access to it, even though you may still retain certain powers within the trust. In many cases, the person setting up the trust, the grantor, that would be you, can serve as the investment trustee, maintain control over how the assets are to be invested and who is supposed to be renting the property, and a lot of the main decisions that needs to be made with the underlying asset. If the rental properties are held in an LLC that is owned by the asset protection trust, the grantor, again, that would be you, can also remain as the manager of the LLC, allowing you to have active involvement into the day-to-day operation of the LLC. This protection comes not from giving up all control, but from the legal separation between you and the trust ownership of the actual asset. That separation has to be respected by the courts, which means the trust needs to be properly structured, usually under state with favorable domestic asset protection laws, and established well in advance of any creditor issues. While an irrevocable asset protection trust can offer strong protections, it is complex and it is not for every investor, but in the right scenario, it allows you to protect your assets without fully stepping away from management or income. All right, so now let's talk about a hybrid option, combining LLCs and trusts. Here is where smart planning really starts to come together. You can combine LLCs and trust to get the best of both worlds. Liability protection during your lifetime and estate planning efficiency when you're gone. This is what I call the hybrid approach, and it's become a go-to strategy for many of my clients with growing or diversified rental portfolio. Here's the basic structure. You set up LLCs to hold your rental properties. These create a liability barrier between your real estate and your personal assets. Then, instead of owning the LLCs in your personal name, you do not want to do that. You transfer the LLCs membership interest into your trust. Most commonly, this is done with a revocable living trust, which gives you control during your lifetime and avoids probate when you pass away. The LLC continues to provide the liability shield, and the trust handles the estate planning side, making it easy to pass properties to your heirs without court involvement. This kind of setup also gives you flexibility. You can outline in the trust who gets what, how it's managed, even how income should be distributed. A lot of times we set up inheritance trusts for the beneficiaries so that when your kids finally inherit your assets, they could get it in such a way that if something happens to them and down the road they find themselves in a divorce proceeding, in a lawsuit, car accident, that creditor wouldn't be able to access the assets, the inheritance that you're giving them. At least it will make it a lot more difficult. So we can really provide continuing asset protection planning within this sort of trust for your beneficiaries. For those clients who want to go further and add asset protection for the LLC interests themselves, there is also the option of using an irrevocable trust. With the right structure, you can stay as the manager of the LLC and even retain investment control within the trust while still adding a layer of protection from future creditors. It is more complex, but for the right client, it can be a powerful upgrade. The bottom line is, when done right, combining LLCs with trust gives you both operational control and strategic planning during your life and unfortunately when you're not here. All right, since I am in California and I practice in California, I do want to talk about California specific considerations. California has some of the unique laws in the country that affects asset protection planning. First, we have Proposition 13, which limits property tax increase as long as the property stays in the same ownership. So when you transfer the property from your ownership, from your name to the name of the LLC or some other structure, making sure that the transfer is done in such a way that property taxes does not reassess becomes extremely important. California also has what is called the single member LLC issue. If you're the only member of your LLC, some courts have questioned whether you really get the same liability protection as the multi-member LLC. This is still evolving law, but it's something to consider in your planning. Our wonderful state of California also imposes an annual minimum 800 franchise tax on LLCs, regardless of how much income it's generating. It's not a huge expense, but it's something to factor into your cost-benefit analysis, especially if you're creating multiple LLCs. All right, so now let's talk about common mistakes that you want to avoid. I see property owners make the same mistakes over and over again, unfortunately. The biggest one is what I call set it and forget it planning. They set up an LLC or a trust and then never maintain it properly. Your asset protection is only as good as your ongoing compliance. Another common mistake is putting all your properties into one LLC. While this might save you some administrative costs, it defeats the purpose of asset protection. If you have multiple properties in one LLC and something happens at one of the properties, all the other properties in the LLC are going to be at risk. I generally recommend separate LLCs for each property or group of properties in the same location. So my general recommendation is you want to have separate LLCs for each property, or maybe you group certain properties that are within a certain location, or they have a certain price, or there's very minimal equity in there. But in general, you want to try to keep them separate. All right, so now you're thinking, which option is right for me? And since I am an attorney, I'll have to say it depends on your specific situation, but here are some general guidance. So if you own one or two rental properties, you still need to think about both asset protection and estate planning. In California, property values are very high, and so even a single property can trigger probate and expose you personally in a lawsuit. At a minimum, consider using an LLC to hold the rental properties you own. Have the LLC owned by your revocable living trust so that it sort of simplifies the succession planning. If you have multiple properties or your portfolio is growing, I would say you would most likely benefit from a multi-entity structure. For example, you would have separate LLCs for the initial property. All those LLCs will be held by a holding company. A lot of times we use Wyoming Holding Company, and then we'll have the Wyoming company placed and held inside of your revocable living trust. The revocable living trust can provide the estate planning side and probate avoidance. And for those of you needing a stronger credit protection, I would suggest an irrevocable asset protection trust. These allow for protection without necessarily giving up full management or control, especially when you use them in combination with LLCs. If your main concern is avoiding probate and planning for your heirs, a revocable living trust is essential. But by itself, it won't protect you from lawsuits. If the property has tenant or liability risk, you still need an LLC as part of your plan. Now that you understand how to protect your rental properties, you need to think about what happens to those properties when you're gone. Even with the best asset protection planning, family disputes over inherited properties can tear families apart and destroy the wealth you've worked so hard to build. So in my next video, I'm going to share the strategies I use to help families avoid these conflicts. I will walk you through real cases where proper planning kept families together and unfortunately cases where poor planning led to years of litigation and destroyed relationships. The video is about how to keep your kids from fighting over property after you're gone, and it is essential viewing if you want to make sure your asset protection planning actually protects your family's future. Don't let your hard work become a source of a family conflict. I look forward to seeing you over there.